The record date is August 1st, 2007. The CPI report, Child Protection in Iowa, brought to you by Vocal, Victims of Child Abuse Laws. You can watch our program on Mediacom Channel 15, Sunday afternoon at 1 o'clock. Again, the program is repeated Wednesday evening at 9:30. You can email us at vocaliowa@mchsi.com. We appreciate and take telephone calls from parents who can use some one-to-one information that we've learned for 20 years. We appreciate the telephone calls from the parents to try to help them. My number is 276-3956, and John's number is 282-2672. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. CPI, that stands for Child Protection in Iowa. Two major parts of our mission. One is, as Don said a moment ago, assisting people on one-on-one basis who are having difficulties with the Department of Human Services and would like to talk to someone who knows a little bit about how they function. We're not attorneys, so we do not hold ourselves out to practice law before the bar. But sometimes it helps to have someone who has been in that situation, who has spoken to people in that situation and knows a little bit about the requirements for parents and the requirements to get you out of a snag. The laws are written very craftily to protect social workers and to ensnare parents. So it helps to have someone to give you some guidance along the way. And that's what we intend to do. That's mission number one. Mission number two is simply to influence public policy as it relates to child protection issues. And this takes quite a bit of work too at the state legislature and other locations where, in fact, this program is part of that mission to let people know what's going on in the department and to influence to the best we can public policy as it relates to children and families. We'd prefer to see that pattern kept alive. The whole idea of the family is being, by all observers, disintegrating very rapidly in this nation, and it seems as though the nanny state is preferred for one reason or another. There are a lot of little tips that helps along the way. For instance, what do I do when someone knocks on my door? What are my rights? Do I have to entertain anybody who knocks on the door and says, I'm here from the state, I'm here to help you? Do you have to let them in your house? And the answer is no. And if they did a good job in the class that they were assigned to, on class on the Fourth Amendment rights, they'd know better than to ask you in the first place. But we have people who come with law enforcement officers to the door, and because there's a law enforcement officer there, you think that you'd better comply. But without a court order, the law officer has no right on your side of the threshold, has no right to cross your threshold. And you can very politely tell that officer, nothing doing. You don't come in my house. We had just a recent case where they move in, and because there's a law officer there, the parent thought it was mandatory to let the social worker come in to check to see if there's running water and to check to see if there was food in the refrigerator. Now that, of all things, without probable cause, is an invasion of your privacy. There are constitutional violations here when people attempt, well-meaning as they might be, to come to your door and try to protect your children by checking your refrigerator. I'm not sure that these things are well based. I'll give you one of the measures by which social workers are now dealing with cases. It's on a safety first basis. That is, we're going to make sure that the child is safe. So you'll hear the term safe all over an assessment that is written on your family, and they'll because of safety concerns, they'll have you doing all kinds of things. For an example, a social worker can say that your children are not being supervised by individuals who are responsible adults. So if you have a 14-year-old watching your 4-year-old as a babysitter, then you might be called upon to sign a contract that you're not going to do that anymore. Now, technically, there is no statute that states the age of the babysitter, how old the babysitter must be. There's some 10-year-olds, I think, that could serve well as babysitters, 12 years old. Certainly by the time they get to 14, and in the South, 14 is age for motherhood. It would seem like to me that some consideration should be given for that person who is old enough, mature enough, and who knows best about whether that age is sufficient, but the mother or the father who leaves children with a young person. But what they'll do is they'll simply say, well, I don't believe that your case, that your child is safe unless you sign this contract. So you sign the contract. Now what does that say? That says not only are you admitting that your parenting is deficient because you chose somehow to get a babysitter that was too young, so you must agree to get an adult babysitter after this. Well, not all people are able to find adults who have the time and inclination to babysit. It seems to be a good occupation for children in the ages of 12 to 19 to babysit. And the DHS workers should not be the ones who make that determination for a parent. But because you have signed the contract, you have demeaned yourself as a parent. Not only that, but you have demeaned the child who was doing a responsible job of babysitting, because you say because of your age, you're too irresponsible to take care of a 4-year-old child. Well, this, I think, is an unnecessary intrusion into family life. And I think it comes time for us to draw a halt to this kind of official behavior. Well, Don, I'm going to have you read part of the story here. I'll get it started off, but there are a number of things that are coming about. By the way, we've made some changes in our studio arrangement. You may not be able to tell it on the air because we've kept the same cameras and same sound system. We haven't found technical improvements for those things, but we have made some changes in arrangements. Over the years, you can accumulate a huge stack of wires going from here to there to here to there to attach all of the equipment that it takes even to run a small studio like this.
So you must have done spring cleaning, John.
So I did some spring cleaning, and I checked through that wire stack, which wasn't quite knee deep yet, and I'd find wires that weren't connected to something, and then I'd trace each cable to see where the other end went, because if this end isn't connected, I wonder why where the other end is connected, and I found out that that end wasn't connected. And first thing you know, I had a huge plastic basket full of wires that weren't connected on either end. I counted the number of power strips that I had running this little studio. The number of power strips amounts to 12. That's probably too many power strips, but that's what it takes to run a little tiny studio like this. We have 3 or 4 functioning cameras at all times, and at least 4 monitors running, a sound control board and a video board, and 3 VCRs, 2 DVD players, and 1 DVD recorder. I missed 1 monitor. The monitor's off right now, but it's a monitor that takes care of the DVD recordings. So it's been quite a struggle making all of these changes in this little studio, but we'll be trying to improve it from time to time to make it as comfortable and as efficient and as technically accurate, technically productive as possible. In our world, it seems that war is almost a daily occurrence. It seems as though we cannot get far away from war. And for the last several years, we've been engaged in a war in Iraq. And it's not surprising, I guess, that the child protection people want to be part of that war effort. And it has some drawbacks. It has some features in it that are interesting to look at. Well, the American Medical Association has looked into what's happening here in these war efforts as it is applied when DHS moves in. And there's no doubt that war claims casualties of the innocent, but injury is not expected among those far from the war zone. And so there are injuries that pop up simply because the family's torn apart. And this is particularly true of single families where a mother has volunteered, has been injured or killed in action. Now they say that females aren't actually in action, but when you go to a violent place like Iraq, you can expect to encounter some difficulties. Well, the American Medical Association reveals that many of those who suffer from armed conflict are living within the same homes that deployed soldiers leave behind. Rates of neglect and abuse of children of servicemen and women, and that abuse has risen 42% within the family when the enlisted parent was deployed on a combat mission, according to a new study led by senior health analyst Deborah Gibbs of the RTI International, a research institute in North Carolina. Previous studies have shown an association between combat-related deployments and higher levels of stress in the family, and it is this stress that is thought to play a major role in the maltreatment of children by the parents who stays at home. So that homebound parent, according to the American Medical Association, is causing some real problems. Would you pick it up from there, Don?
This is fallout from the war at home. There is no doubt that war claims casualties of the innocent, but injury is not expected among those far from the war zone. A new study in the August 1st issue, of the Journal of American Medical Association talks about it. The current study is the first to take a comprehensive look at how deployment affects child neglect and emotional, physical, and sexual abuse. Backed by funding from the U.S. Army Medical Research and Material Command, the researchers harvested data from the U.S. Army Central Registry of 1,771 families worldwide with at least one instance of child neglect or abuse between September 2001 and December 2004, a period during which many soldiers were deployed to Afghanistan and Iraq. Now, we haven't talked about this in the past, but there are definitely children from the soldiers, and no doubt there is possibly some abuse could be going on there, and we know a lot of false accusations as well. The results show that a staggering 1,858 parents had maltreated their children during that period, boys and girls in equal numbers with an average age of 6. Nearly 10% of these parents neglected or abused their children on more than one day. The number of times a parent was deployed, however, whether once or twice, did not significantly affect the rate of maltreatment. Researchers speculate that by the time of a soldier's second tour of duty, the homebound parent has developed at least a few coping strategies. The study shows that mom is the one taking it out on the kids. Well, the father's not there, so if there's statistics show it, that would be the case, I would guess, whether that's true or not. During the deployment of her soldier husband, rates of child maltreatment tripled, neglect quadrupled, and physical abuse nearly doubled. That also shows that there needs to be a father in the home, isn't it, John?
Yes, that's right.
The father is gone, therefore problems can develop. Female spouses are the ones that stay at home when soldiers are deployed, says Gibbs. Well, that's not totally true. We know that females go to war also. They deal with the stress of single parenting, worrying about a spouse, and holding down a job as well. We recognize the military families do an amazing job at getting through these situations that are tougher than many of us could ever imagine. Abusive women were more likely to be Caucasian than Hispanic or black, suggesting that there may be differences in the way white mothers cope with stress compared with black or Hispanic moms. The study's authors write that the racial difference may have to do with the mother's employment status or her willingness to ask for outside help. In contrast, male spouses showed no increase in maltreatment when their wives were deployed. The study controlled for circumstances often linked to a child maltreatment, such as substance abuse, socioeconomic status, and age of the children, making it evident that the deployment was the determining factor. Army families certainly know how stressful deployments are. Better than any of us, said Gibbs. I don't want any Army family to feel like we're suggesting that they're more likely to experience abuse and neglect than other families. No studies have looked at other branches of the military in the same way, says Gibbs. Government statistics note that in 2004, 1.1 million children under the age of 18 were maltreated in enlisted soldiers' families. Gibbs and colleagues cite another soon-to-be published study that found the rates of neglect in U.S. Army families increased sharply between 2001 and 2004, reversing a decade-long downward trend. We certainly aren't surprised that neglect would be the type of abuse that would go up, said Dolores Johnson, director of the Family Advocacy Program for the Army. Because, quote, because we have extended periods of separation of parents, and when that occurs, our own analysis indicates that child neglect is likely to rise. Johnson says that the study reveals that continuous deployment of 12 to 18 months is causing families to feel, quote, a certain degree of strain, unquote. The stay-at-home parent certainly begins to feel that pinch, either in forms of depression or neglect situations, said Johnson. Even though these families are resilient, I think that they know that these deployments are taking a toll. According to Johnson, the Army has invested more than $100 million this year in networks of programs to help the parents at home, particularly young mothers, deal with stressful parenting issues, from changing diapers to calming crying babies, with the help of nurses, counselors, chaplains, social workers, and Army community service staff. Some of that assistance, from phone counseling to in-person guidance, can be found through, and you can look this up on the internet, _myarmylife2.com / as you see that on the screen. You can leave that up there a moment while I continue on, John. Or you may have to type in http / or semicolon / www dot in there, as it's showing on the screen. Johnson says that the message the Army hopes this study will convey is that families that know about these services make a special effort to tell their friends and neighbors about what is available, so that other families don't feel so isolated and overwhelmed by the situation that they're in. I think that's good advice there on the end, John. We need encouragement from others that have went through the situation.
But isn't it interesting that they have tons of money for this protection issue through the military, and it seems like free-flowing money. What was it? Over $100 million to help parents cope with the stress of changing diapers. That seems rather strange to me.
Well, some people don't like to change diapers.
Well, it's one of those things I suspicion that comes with parenting, does it not? Well, let's see.
Incredible.
I'm missing one of my sheets here. Okay, here we go. I want to, before introducing Terrance Walker, want to get one quick story in here. This is an Iowa story. Um, has to do with the dismissal of a child abuse case. The reason why I want to mention is that it doesn't happen very often. The laws are written so that dismissal isn't always easy to come by. So I wanted to put this one on television. Frank Santiago registered, and I was going to say Register and Tribune. It's a Register staff writer. They don't have a Tribune anymore. They fired the afternoon newspaper. The Iowa Court of Appeals on Wednesday upheld a judge's decision to throw out a child abuse charge against a woman who said a lack of sign language interpreters prevented her from getting a speedy trial. The appeals judge rejected Mills County prosecutors' claim that limited resources and trouble finding interpreters justified delays in Marla Hay Hansen's trial. Deshawnay's Bird Cell, Hansen's lawyer in Glenwood, called the ruling a great victory for the hearing impaired in Iowa. Hansen, who is legally deaf and reads lips, was accused of spanking a child with her hand. Isn't that interesting? She faced 5 years in prison if convicted.
Oh, listen to that, parents. How many out there that use their hand to spank their children?
Right.
And you could face 5 years in prison for doing that.
So,
What country do you live in?
right. So they shouldn't have found her guilty in the first place. Shouldn't have charged her in the first place.
He wasn't found guilty. You're right. Charge.
Yeah.
Somebody that doesn't like spanking.
Yeah. Right.
Was motivated to do that
Yeah.
for that woman.
Right.
Who was probably trying to just properly discipline her child to help that child to grow up to be the adult she should be.
Okay, Hansen, who is legally deaf and reads lips, was accused of spanking a child with her hand, and she faced 5 years in prison if convicted. She asked that the statements she made to police about the incident not be used against her because there was no interpreter present. A judge agreed and barred the statements. Records show that District Court Judge Charles Smith later dismissed the charge because the case wasn't ready within the 90-day limit. Eric Hansen, Assistant Mills County Attorney, said that the delay was caused in part by a misunderstanding between the court administrators and defense attorneys about who was supposed to provide the interpreters. He said that it was determined that the county was responsible. Hansen claimed that that the finding certified interpreters was difficult in the area. If you get outside of Spanish, then it gets to be really a problem finding resources for interpreters, especially sign language interpreters, he said. Under the clear language of the law, the appeals judges ruled Hansen didn't give up her right to have an interpreter. The judges suggested that the Iowa court's officials be prepared to provide timely help for hearing impaired because although this case may be involve somewhat unusual circumstances, having hearing impaired person either as a defendant or as a witness in a criminal case is certainly not unique or highly unusual circumstances, but instead is and will continue to be a recurring event. So congratulations to the Court of Appeals who rendered an appropriate decision in this case. I saw one other area up here, maybe I can find it once again, that was
I'll inject that the law states that they have to provide an interpreter, and so the county attorney needs to follow that law, just like he wants to enforce it on parents and throw them in jail. He needs to enforce his own laws, or
That's
the
right.
laws he's required to enforce. John?
Okay. One thing that's disturbing me is I forgot to check all the mics. So I guess we'll have to check the mic on the air now to make sure that we do have a mic here ready and active for Terrance Walker. The reason I wanted to speak about this particular case is it's a court case, and Terrance Walker gives us some guidance as to how to think about revising uh, uh, in the court situation. Is that an extra one?
Yeah.
Okay.
Can you
Well,
hear me, by the way, since we're going to do a live test?
okay. Hey, yeah, you bet. Okay. Yeah, sure can hear you.
Okay.
Here now, Terrance Walker, our expert on court reform.
Thanks a lot, John. Well, you got the thing switched all around here. I don't know which way to face here. Am I supposed to face this way? Okay, good. All right. Well, yeah. Thanks for having me back on the show. I know it's been some time, and I even had a lady at the Walgreens parking lot today. Just kind of, you know, highlighted the need for me to be on the show once again and do another show. Um, Her name I think was Joanna Loggins or something like that.
I've heard of her.
Um, she said, "Well, when you gonna be back on the show?" So I just told her. I said, "Well, I'm going to go over there now, just uh, just to let you know." So it just made me happy to think that someone's out there that is getting some insight from this program, because it's something that we need to all be aware of, is the court reform. And I know John and Don talk a lot about child protection as well, and those are things that we all need to be aware of what's going on as well.
Bring your
Um,
mic in just a little closer if you can.
okay,
Okay.
there we
Hey.
go.
Okay.
But wanted to say hi to her, and we're back in effect with the court reform discussion, and we're going to discuss a interesting case today. I thought it would highlight some of the power struggles that really go on. You don't really hear about what goes on inside the courthouse when it respects different judges, different clerks and bailiffs and court administrative officials and staffers. But there's a really interesting case which actually brings out what really goes on in some of the courtrooms. And this actually takes place in the state of Nevada, and in more particularly in the city of Las Vegas. I guess what goes on in Vegas doesn't always stay in Vegas. And the highlight of this article is "You're Not the Boss of Me." And it's a picture of Judge Halverson, and she is involved in a bitter struggle of power with the Chief Justice of her courthouse, which is Judge Hardcastle. Both female judges. Uh, Very interesting power dynamic here. Um, One actually, Judge Halverson, she actually used to clerk for the former Chief Justice for the 8th Judicial District in Nevada. And she, it describes her in this article from the Las Vegas Review as a morbidly obese uh, woman. I mean, it cast her in some of these legal filings. I guess it says it cast her as a morbidly obese, incompetent woman abusing her power to settle scores accumulated there in her 9 years as a law clerk. And how all this came about, this power struggle between these two women judges in the same court district in Nevada, well, it appears that Halverson had been working for 2 years as a law clerk, mostly for the chief judge. And Hardcastle took the bench in 1997. Halverson was there for 9 years by the time Hardcastle ascended to chief judge in 2004. And just 4 days after being elected chief, she fired Halverson. And it was intended to be a slow motion termination, with Halverson getting about 3 months' notice. But several weeks later, Halverson announced she intended to run for judge in one of Clark County's family courts, where she would be challenging an incumbent. And the incumbent just happened to be Hardcastle's husband, which was Judge Gerald Hardcastle. So Halverson was fired on the spot. Then she narrowly lost that race, but she didn't go away. She's a very determined lady. Um, she complained to the Standing Committee on the Judicial Ethics and Practices Board, and she said that Kathy Hardcastle had improperly campaigned on behalf of her now ex-husband. The committee determined that Hardcastle indeed violated judicial canons by handing out her husband's campaign brochures and sitting at his campaign tables, and it admonished Gerald Hardcastle for failing to encourage his family to live up to the same standards expected of judges and candidates. Last year, Halverson was elected to succeed Judge Michael Cherry, who had been elevated to the Nevada Supreme Court. And Halverson, who weighs 425 pounds and moves about the courthouse with an electric scooter and breathes from an oxygen tank through plastic tubes attached to her nostrils. Though her health has become an issue in the campaign, she managed to win with a slightly more than 50% vote. And though some expected fireworks when the 49-year-old Halverson took the bench in January, no one could have dreamed the events that followed. Now, not only were there some issues with what she's done in the court, in her court proceedings, but what she's done behind court doors. For instance, Halverson's bailiff, a black man, says he was ordered to rub her feet, give her back massages, put on her shoes, change her oxygen bottles, and pick up papers, cookie crumbs, and sunflower seed holes strewn on the floor of her chambers. He eventually filed a claim for discrimination based on race, religion, and sex. The bailiff, Johnny Jordan, was to be waiting for her each day at the building entrance at 7:30 a.m., though she often arrived at 8:30 or later. And then Halverson, the bailiff, and other staffers alleged she'd sometimes throw items on her floor and order Jordan to pick them up. And then when Halverson's mother visited one time, she asked her daughter, "Is he your servant?" A courtroom clerk alleged that Halverson had her swear in staffers so she could ask them pointed questions under oath about what they might be telling other judges about her. On one occasion, she said Halverson had her husband sworn in so she could ask him, apparently under penalty of perjury, whether he would have their house cleaned in time for her mother's visit. When the first witness took the stand in Halverson's first criminal trial, Halverson fell asleep. According to several staffers, she also slept in the court, and court employees developed ways to signal each other when it was time for someone to wake her up. Twice, Halverson was said to have spoken with criminal juries when none of the lawyers were present. And in at least one of those trials, her potentially unethical action forced prosecutors to offer more general plea agreement than the charges warranted, according to court documents and confirmed by Michael Burgmaier, the courthouse public information officer. In a meeting with several colleagues, Halverson admitted to berating lawyers in open court for not having contributed to her election campaign. And she screamed at staffers, referring to them with such demeaning epithets as the elf, the evil one, the bitch, the antichrist, and several more I can't really say on the air here. Barely a month after Halverson took the bench, she was visited by two Nevada Supreme Court justices who expressed to her concerns about how she was treating her staff. Halverson had clerked for one of the justices, Mark Gibbons, when he was acting chief judge in Las Vegas. The other was Chief Justice Cherry, who had preceded Halverson on the bench. Neither Gibbons nor Cherry will be sitting for Halverson's Supreme Court case, which is due to be decided here pretty soon. On April 6, Halverson met with a committee of 3 judges named by Hardcastle to work with her on her various complaints about her behavior. Halverson had quick answers to a laundry list of questions about her behavior. Concerning the foot and back rub, she said she had told the bailiff to stop being too familiar. Concerning her bailiff, being required to prepare her lunch for her in a microwave oven in her chambers restroom, which staffers say has a foul odor, she said the bailiff worries about her and she needs to eat. I'm sorry, I had to laugh at that one. I'm trying to do this with a straight face, but it's just the whole thing is interesting, but and hilarious at some points. But according to the memo, one judge at the meeting suggested that Halverson get professional help. Halverson agreed, saying she would like a business coach to help her and her staff communicate better. One of those meetings was Judge was at the one of the meetings was Judge Stuart Bell, a two-term district attorney in Las Vegas. As everyone ready to depart, Bell reiterated the suggestion that she seek help, this time in a more pointed fashion. If you can't see it, you can't fix it. Get some psychological help. It was the last time Halverson would meet with the panel of judges. Halverson was told to meet with them again on April 12th. She sent back word she was in trial. The judges waited for her until 6 p.m. to no avail, and later determined she had not been in trial. She stood them up for a meeting again, rescheduled for the next morning. In early May, Halverson fired her assistant, Eileen Spohr. Spohr complained that some of her personal belongings had been left in the office. On May 9th, at the direction of the Chief Justice, acting Chief Judge, an entourage of armed bailiffs, the court administrator, an assistant court administrator for human resources, and a videographer accompanied Spohr to retrieve her belongings. When they knocked on the door to inform the judge about what they were doing, they were greeted by two unauthorized private bodyguards, apparently hired by Halverson, who informed them that the judge would not leave her office and that she considered their presence an illegal search. Would you believe that? As the videographer rolled, Spohr looked for a Rolodex and several envelopes containing traffic tickets belonging to friends. Halverson called 911 to report that she was barricaded in to hold off what she believed was an illegal attempt underway by courthouse personnel to enter her chambers. In a transcript of the call, the dispatcher pressed for details. He asked the age of the fired assistant, who was in the group of Halverson's chambers at the door at the very moment. "Oh, I don't know," she says. "She looks like she's about 80, but I think she's 52 or 53. So, on May 15th, Halverson filed a lawsuit against Hardcastle, an unusual petition for a writ of quo warranto that challenges the chief judge's authority over Halverson. She alleges the judge's actions were not only illegal but also punitive. The writ says that the chief judge has only additional administrative duties in that position and asks by what authority Hardcastle could: 1. Require Halverson to meet with the three-judge committee named by Hardcastle to review her judicial and extrajudicial actions. 2. Remove all criminal matters from Halverson's docket on recommendation by that committee. 3. Bar Halverson from the courtroom the voters had put her in. And Halverson is represented by prominent Las Vegas attorney Dominic Gentile. He has a United States Supreme Court victory with his name as a petitioner. And that opinion, I guess it struck down limits on lawyers speaking to their press about a pending case. And it is widely believed that Halverson, perhaps one of the best legal minds in town, did much of the legal research and writing in the writ. She also did not respond to a request to interview. So, to sum it up, I think what we have here is a failure to communicate. But I think it's very interesting how all this is playing out because, for once, it's the judges that are personally embroiled in a legal case between themselves, and for two, it's interesting to see them going back and forth as it pertains to to their authority or lack thereof. So I don't know if I didn't really have too much others here. Oh, did you hear about the Chief Judge of the United States Supreme Court?
Yes, Roberts.
He apparently had another seizure.
He stole a couple of my names. Did you know that? John Roberts. My name is John Robert.
Oh, okay. There's also a chief judge or judge somewhere named John Harvey, isn't there?
Yes, in the state of Georgia, uh, state of Georgia, he was the Supreme Court senior Supreme Court judge of the state of Georgia, John Harvey. You bet. Okay.
Wow.
Any other comments there, uh, Mr. Reformer?
Well, I think that we need to really. I'm gonna bring it back home here. We've actually been. I've been slacking here. We've been really busy with business here, and
You've been
past
you
several months.
you've been deployed.
I've been deployed with business.
Okay.
I'm not been deployed to the army or anything like that.
Okay.
But yeah, so what we're going to do here in the next few months, we're going to start getting some serious commentary on, because I think it's high time, especially with the election coming into play here. We want to see what the next supposed power brokers, politicians that are going to be planning on being elected in office here this next term will be doing as it pertains to the judicial reform. And I'm sure you guys want to know exactly what they're going to be doing as far as it pertains to families and child protection
So
reform.
you're going to give us some schooling on reform? Is
Yeah,
that true?
We're
In
gonna
that case,
examine what exactly they're going to do or not going to do, and as it pertains to judicial reform, because we all need it. We got a situation
Right.
where each year in and year out, the past several years, we have got more and more and more people being incarcerated in a system that's not working, and it's just. And then on top of that, we've got, as it respects child protection issues, we've got more and more people losing their kids, and just all kind of crazy mess going on. Then you have situations where judges are battling each other in another court. So,
That's right.
and they're, telling their staffers to go pick up their sunflower seeds off the floor and stuff like that. It's all kind of weird stuff.
This is an unusual.
Interesting. Very, very unusual case. And, there's a comment in the article where as a teacher even said, well, it was a civics teacher, high school civics teacher. She had said something in there concerning the whole incident. She said, well, I hope this case never goes away. This is the first time I've gotten our students to actually read the paper. So
Okay.
they want to know what's going on, the juicy details of what's going on, because it's something that you don't really hear brought out. The power struggles go on,
Right.
but it's never escalated to the point to whereas it's all in the media and it's all in the court files, and you've got hundreds of pages of sworn affidavits saying the judge did this or the judge did that, and it's just really amazing how far this has actually went.
I got a comment on the, you were talking about the court workers, the court bailiffs.
Yeah.
I'm thinking that some of them have a hard time working for their boss, the judge. I wonder if they have any choices. I think they're, I'm not sure, appointed or told you got to work for a certain judge, and they don't have any choice. They must. I think they just work for the system, and they're told to go here and told to go there. And if they happen to get hooked up with a bad judge, maybe we ought to feel sorry for some of those workers.
And one job requirement I think that a lot of them have is that they can't have a mind of their own. Because I've been in a situation. It was a very questionable situation where where the staffer or the supposed bailiff in this instance didn't really have any authority to do what they were told to do. Because I think it was in the processes of paying a ticket or looking up some court case or something like that, and the lady that was at the desk had said something to me very insulting, and I said something insulting back. I said, well, you don't have to insult me. And she told the judge, and the judge told the bailiff to escort me into the courtroom. Now, I didn't have a legal case pending, so under what authority does a judge have to tell somebody to escort you into the courtroom when you don't have a legal case pending?
Or to
It doesn't
ask
make
the
any
bailiff
sense.
to escort someone out of the courtroom.
Exactly.
So,
And that's some similar situation to what you're facing right now.
It's called lack of jurisdiction, And when a judge does that, when a judge acts without jurisdiction, and when a judge acts without proper decorum, and when a judge acts contrary to public policy as far as courtesy and a few things like that, to me, that judge needs to be shown the gate. And
Yeah.
I don't think we need to be putting out a lot of money on judges of this sort. Don, there are some troubles with foster care. Would you tell us a little bit about what happened when there was a suit regarding foster care of some children?
I'm not. Just a minute, John. Okay, I found it here.
Okay.
We got onto all kinds of judges' issues there, and I got distracted. This comes out Wednesday, June 6th of this year. 4 siblings awarded $6.2 million in Seattle foster abuse case. 4 siblings who were abused in foster care were awarded $6.2 million by a King County jury Tuesday. A verdict that now stands as the largest of its kind in the state. The jury decided that the state acted negligently when it licensed Pearl Hall to be a foster mother nearly 20 years ago, and that it failed to monitor the home after the 4 kids were placed. The abuse was discovered when one of the children, then 7, ran away and got help. The siblings were subsequently placed in another foster home in which they were physically disciplined, although not to such an extent, court records state. In the foster home, they physically discipline them. And when they're in their home where the parents love them, if a parent touches them, that's child abuse. Okay, it goes on. No groups of kids has slipped through the cracks as thoroughly, said attorney Rebecca Rowe, who represented the youths with co-counsel Kathy Goter. The State Department of Social and Health Services, which oversees foster care, issued a statement after the verdict. It is deeply regrettable that these children had to suffer abuse in a home that should have been a safe place, the statement said. Well, I agree to that. We did quote, we did try to resolve this matter prior to trial. Yeah, I'm sure they're afraid for it to go to trial. They might get in trouble. DHS or maybe somebody else. But the settlement negotiations did not bring us close enough to resolution. DHS has been the state's most sued agency for a decade, but most cases are settled before trial.
Can you pull the mic up just a little bit above your mouth? It's giving us, yeah.
Okay.
We're getting too much breath into it.
In 2004, the agency agreed to make dozens of changes to the foster care system in response to a class action lawsuit. The state is considering whether to appeal. A 2003 jury verdict in a foster care case for $8.3 million was dismissed last year by the state Supreme Court, leaving Tuesday's verdict the largest of its kind. The 4 siblings in the case, who now range in age from 13 to 19, came into Hall's care in 1993 because their mother had a drug problem, according to Goter. Goter was the attorney, co-counsel, who represented the youths, Kathy Goter. The day after they arrived at Hall's Seattle home, the beatings began, according to one of the siblings, now the oldest at age 19, who was at home, who was at the time was 5 years old. It was terrible beyond words, said one of the siblings, who is now 18 years old, all under the direction of DHS. According to court documents, the children were whipped with switches, extension cords, shoes, and boards during their 5 years in Hall's care. The beatings left one of the girls with bleeding welts on her back. Pearl Hall, who was convicted of a misdemeanor assault charge, died in 2004. The 3 oldest children also were sexually abused by Hall's son, according to court records. Paul Hall, now 25, is serving an 8-year sentence for child rape. The abuse becomes a regular part of their lives. That's where the DHS put the children into this home. How nice. How not nice. It was part of my routine and my pattern, said one of the children. The Seattle Times generally does not name victims of sexual abuse, but the Williams siblings agreed to be named. Although each of the Williams children suspected the others were being abused, they didn't talk about it. Paul Hall would send the other kids out of the room when he wanted to abuse one of them. And he said he would kill them if they told, she added. Rowe said the Williams kids got only 3 visits from state workers in their first 2.5 years in Hall's care, despite rules at the time requiring visits every 30 days. They could have known about the abuse if they'd checked on us at a regular basis, Robert said. They just fell through the cracks. DHS looks the other way. Of course, they probably knew all about the abuse when they sent the kids there in the first place. Okay, it goes on. Rowe said Hall never should have been licensed. When she applied for a foster care license in 1989, she told DHS that her son had been molested by a babysitter at age 2, that she used corporal punishment, but she'd had a previous emotional breakdown, and that she did not have a steady source of income according to the court documents. She didn't attend required trainings and was deemed not highly skilled in caring for children. She was also in very poor health. Some DHS workers raised concerns about Hall, but these concerns were brushed aside. The state wound up renewing Hall's license repeatedly and allowed her to operate a daycare center. The lawsuit recounts 16 points at which the state should have realized something was wrong. In its defense, well, they always have a defense, the agency's attorneys claimed DHS could not have known about Paul Hall's dangerous I'm not sure what that word
Proclivity?
is. Proclivity. That's a DHS word. I've never heard of it before, to be honest with you. And relied on Pearl Hall's signed agreement not to use corporal punishment. Do you happen to have the next page, John? Thank you. The children, 2 of the children both said that if it weren't for their brother Robert, now age 16, they might not have survived. So sometimes the older siblings do help a lot. As Robert recalled, one day in July 1998, Pearl ordered him to come to her for a beating. Instead, he took off running. Only 7 years old, he had no idea where he was going or what he would do. But he wound up in a grocery store. The store clerk called a police officer to take him home. Robert recalls guiding the officer all over town, pretending he wasn't exactly sure where he lived, just so he wouldn't have to return to the halls. Finally, he told the officer he was being abused. Quote, we're all little kids, and we were done wrong by these people, Robert said. Quote, we had no choice where to live. Unquote.
Okay, thank you for that story. It seems as though foster kids are getting the short end of the stick here. With all the money they're putting into foster care, one would think that they would get a better shake out of life. Here's a couple of numbers that may be useful to you as you try to protect your family. We'll see you next week.